giving her money, aren't you?
Didn't look at it that way. I gave her a book.
Well, you're not looking at it that way, but that's what happened. You gave her money, and you gave her a book that cost you money, right?
Yes.
How much did that book cost you?
$9.
So here you are buying her a gift that's $9, right?
No, it was not a gift.
Oh, did she give it back to you?
She offered it back to me.
No, I'm not asking you if she offered it back to you. She never gave it back to you, right?
I didn't ask for it back.
Did I ask you whether or not you asked for it back?
So what are you asking?
I'm asking you whether or not isn't it true that she never gave it back to you, right?
She offered it back to me.
I'm not asking you whether or not she offered it to you. You understand that's not my question. You understand that, right?
Yes.
My question is, isn't it true that the book was never returned to you? Right?
Correct.
And so you did this because you believed, or for whatever reason, you started to like her, right?
No.
Oh, so you dislike her.
I didn't say that either.
So you do like her then?
I can't answer that question, true, yes or no.
Well, why not? You spent how many? You went to see her on 12 separate occasions, right?
Depends what you mean by like.
I'm asking you, isn't it true that you went to see her on 12 separate occasions, right?
As part of my role to evaluate her, yes.
Yes or no? You did go see her on 12 separate occasions, correct?
Yes.
And you spent many hours with her, right?
Yes.
And you talked about a variety of things, right?
Yes.
Isn't it true that even after all this time and after all these visits, the reason you got her this book, you're saying is just because there was no reason?
There was a reason.
And the reason was that you wanted to give her something, right?
No.
Well, you did give her something, didn't you?
Yes.
And there is a code of ethics, correct?
Yes.
And that code of ethics prohibits you from providing gifts to somebody like the defendant, doesn't it?
It wasn't a gift.
Sir, isn't it true that it went over and it got to her, didn't it?
She was suicidal at the time.
I'm not asking you whether or not she was suicidal, right? Am I asking you that?
No, you're not.
And if she was suicidal, you're not the treating physician, are you?
I'm not treating her.
Well, if she was suicidal, it was somebody else's responsibility to take care of it, right?
Judge, objection. Can we ask the state not to yell at the witness? It's not necessary. Please.
And in this particular case, you told us that you thought the defendant was suicidal, right?
She was telling us that she was going to kill herself.
Sir, now you're changing the story because now you're saying she was telling you.
Objection to the mischaracterization of changing the story. Sustained.
Sir, didn't you tell us just minutes ago that she was suicidal?
She told us she was suicidal.
I understand that's what you're saying now. I'm asking you to think. You don't have any memory problems, do you?
No.
I'm asking you to think back to maybe 5 minutes ago. And 5 minutes ago, isn't it true that you told us, when I was asking you about the gift, you told us, well, she was suicidal. Do you remember that spontaneous statement coming from you?
Yes, but I didn't mean that she was going to kill herself right there. She had told everyone.
Sir, I'm asking you if you remember the statement, yes or no.
You're not allowing me to explain this.
All right, counsel, one at a time.
Okay, Kirk Nurmi, a lot of legal analysts thought he went a little bit way over the line, including your co-counsel there, Jennifer Wilmot, as she said, could you ask the state not to scream? Your thoughts on his cross-examination with Dr. Samuels?
Well, again, that kind of falls into the category of commentary about Mr. Martinez that I can't offer, I've just heard the clip. As I write the second book, I'm going back through all of that. But I certainly think that all Ms. Wilmot's objections were well taken on that point regarding the cross-examination, Dr. Samuels, and it goes on and to continued objections that I also think were certainly warranted as well.
Okay, we're going to get to calls in a second, but
sure.
Remember to get the new book. It's called Trapped with Ms. Arias, and in the book you do speak about wanting to get off the case. Now, this was several times, or was it one time that this happened that you wanted to get off the case?
Well, I was doing an interview last week, and somebody said they started counting at like 5 or 6, and there were certainly several motions to withdraw. When I talk about being trapped, I describe in the book really the initial motion when I was planning to leave the public defender's office and going out into practice, with the plan being that I would leave the case behind and the public defender's office would continue the representation. And that's when I talk about that first motion to withdraw and that trap kind of being set in April of 2011. But there were several. I don't even know how many motions to withdraw I filed and or argued in the case.
A lot of attorneys would just like to be there because that's why I asked you for several times, because I would think a lot of attorneys, even if they knew they were going to lose the case, and, Tom Mesereau said right here on King George Radio, the clip that I played for you, that you guys did your job in terms of getting her off the death penalty. You did your job, but a lot of attorneys would just want to stay on the case because it was such a high functioning case. But despite that, even after it was a high functioning case, you still wanted out, right? It's not like you wanted the fame and glory.
I think it was a high profile case from January 2013 until, the day she was sentenced. I don't think it ever stopped, even though there was a lull in between the two trials. I don't think there was ever a time when it wasn't, high profile. But, listen, it's to me, it's about doing the job, and it's not about the high profile nature of it. The goal number one, and all the goals of a capital defense attorney, Mr. Mesereau is right, is to save the client's life. And we did that. And, the attorneys that probably would have liked to have that case probably, what's the saying? How's the saying go? Be careful what you wish for, right? So,
yes,
because,
so
I was on the front line, so to speak, and it's certainly a lot easier to watch and Monday morning quarterback as opposed to actually being on the front lines. But in terms of what we got done, certainly we accomplished our job and won not only one but two trials, saving our client's life. So
absolutely, and that is something to be looked at. Let's go to Huntington Beach, California, and say hello to Sarah. Good evening, Sarah. You're live with Kirk Nurmi, Sarah Kardashian. You're live. How are you?
I'm good. How are you, King?
Awesome.
And very, very nice to meet you and talk to you, Mr. Nurmi.
Hi, Sarah.
Just a couple things. In my opinion,
okay.
I think it was proven beyond a reasonable doubt that it was first-degree premeditated murder. But that's just my opinion. Now,
okay.
So when you said before, and of course everyone wishes Travis to be still alive, honestly, and it was a horrible, horrible thing. But I kind of think that your former client, Miss Arias, I think she would have eventually killed somebody, and there would be another trial with her, or a different trial. But my questions to you are, if you were the prosecutor and you got this case, would you have handled it differently? Would it have lasted this long? And would you have gone for first-degree premeditated murder if you were the prosecutor? And the other question is, and I know everyone has their own style, and Mr. Martinez he's either loved or hated, and so it has nothing to do with Mr. Martinez. It just has to do with how you would have handled it. And the other question is, regarding this trial or any other trial that you would have in the future, would you welcome cameras in the future to any other trial? And let me see. if I have anything else with my notes here.
Well,
I
let
think
him
that's
answer
about
those,
it.
and let's answer those.
But I wish,
then,
I wish you
if
well,
have any
Mr.
more,
Nurmi. I wish you well. Okay, so that's it.
Okay, thank you, Sarah. Let me see if I can handle your questions. I've certainly never been a prosecutor, and I guess I would preface my answer to your question by saying that, or your first question by saying that I am a pretty staunch opponent of the death penalty, which is why I was kind of in a position to be doing the kind of work I'm doing. I detail in the book why I don't think it was ever a death case, a death penalty case, not only in terms of just my general opposition, but in terms of other crimes that it must be compared to. Now, I know a lot of people are going to take shock to that and think this was a terrible killing, and it certainly was, but there are certainly several killings that could fall into the category of Miss Arias's, case. As far as would I have gone, first-degree murder, something of that nature, that's something that my understanding is that they, discuss with a fair amount of their colleagues. I certainly, if I did charge first-degree murder, would have been open to a resolution short of that, because certainly without a death penalty charge, the possibility of conviction of first-degree murder lessens, because death-qualified juries are less likely to convict on the underlying charges than are death-qualified jurors.
Okay, so if, let's say, death wasn't on the table and it was just first-degree murder, would you have handled the case differently? Would you have put different witnesses on? Would you have? I mean, that's what I'm curious about.
It would have been a completely different ballgame. There's no doubt about it. And describing that for you, it might take the rest of the hour, but it would be a completely different ballgame. And I want to, Sarah, I want to get to the second part of your question too, because I think it's an important one that maybe isn't something that I alone can answer, but certainly something the courts in general will have to answer. This idea of cameras in the courtroom, not just in the courtroom itself, but the way that the technology that we have now allows for those court trials to be broadcast. We have to, as a court system and as a justice system, decide, are we going to risk the potential of trials degenerating into reality TV shows? I mean, we have important life events taking place for all the participants in a trial, regardless of what kind of trial it is. And we have cameras, and we have live streaming, and we have all the hoopla that can be generated in Miss Arias' case, for example, that maybe wasn't a part of O.J. Simpson's case because social media was in its infancy by comparison. And now we are in an era where if a trial is broadcast, there's a potential that everyone in the world, the court of public opinion, can all jurors, so to speak, jurors of the public, can sit on their cell phones and watch the trial and weigh in. And we have to be concerned about insulating the process, the lawyers, the witnesses, and the jury, most importantly.
Okay, well, thank you very much for all of that. And you take care.
Thank you, Sarah.
All righty. Good night,
Thank you,
King.
Sarah.
Good night.
Good night.
Bye-bye.
Let's go out to Memphis, Tennessee, and let's say good evening to Wanda Wright. Wanda, you're live on King Jordan Radio with L. Kirk Nurmi. Good evening.
Good evening. Good evening. Good evening. Good evening, King, and it is a pleasure to meet you, Mr. Nurmi, and to talk with you.
Thank you, Wanda.
I just, there are so many questions, but of course I don't have time. But there is a couple of questions that I have. Well, first of all, I haven't read your book, and I'm very excited to get it, to read it. I, like many, I didn't miss 1 minute of the trial. I watched every single second of it. And I wanted to ask you, I think I'm right